These are some frequently asked questions about improper influences on California legislators. First, is there a prohibition against improper influences? In California's Constitution, Article 4, it deals with the legislative branch of government, and it makes it a felony for any person who seeks to improperly influence the vote or official action of a California state legislator. To whom does the prohibition on improper influence apply? Section 15 of Article 4 not only provides that the person who seeks to improperly influence a legislator is guilty of a felony, but also the legislator who is so influenced is likewise guilty of a felony. What are the bases for this improper influence? Section 15 provides four of them. It says a person who seeks to influence the vote or action of a member of the legislature in the member's legislative capacity by bribery, promise of reward, intimidation, or other dishonest means, or a member of the legislature so influenced is guilty of a felony. So let's take each of those four. What is bribery involved? Well, bribery, not surprisingly, is not defined in California law nor in our state constitution. One dictionary definition is the act of offering someone money or something of value in order to persuade them to do something. There is almost no case law on this provision. I found only one appellate court case, and basically the court held that it was not bribery even when picketing constituted an implicit promise that if contractual demands of pickets were satisfied, then the picketing would cease. What might constitute bribery? Well, it seems obvious that bribery under Section 15 is offering money or some sort of other item or items of value in exchange for a vote or other official legislative action by the member of the state legislature. What is a promise of reward involved? The promise of reward is also not defined in California law. One dictionary definition is that someone will definitely get a sum of money that was offered. Now, what might constitute a promise of reward? I think undoubtedly that promise under Section 15 is basically promising a state legislator some sort of financial gain in exchange for a vote or other official legislative action. What is intimidation involved? Intimidation is likewise not defined in California law. One dictionary definition is when you frighten or threaten someone, usually in order to persuade them to do something that you want them to do. What might constitute intimidation? Under Section 15 of Article 4, it might include efforts by someone to get a legislator to vote or not vote, or to otherwise take some official action because the member felt threatened or frightened, i.e., intimidated. And what does other dishonest means involve? This term is also not defined in California law. One dictionary definition I came across is being deceitful or untruthful. Now, while these words mean unworthy of trust or belief, dishonest also implies a willful perversion of the truth in order to deceive, cheat, or defraud the victim. So, what might constitute other dishonest means? Under Section 15, it could include maybe intentional efforts to being untruthful in order to deceive a legislator in their voting or in otherwise conducting official actions.